Hi, this is Steve Carlson. This is an informal reading from an emergency application to the U.S. Supreme Court that's related to a cert petition that is due to be considered in conference by the court on the 23rd of May. That's this Thursday. And so I want to give some information. It's a very important case because it affects the very vital rights of hundreds of Minnesota women who are routinely thrown out of their breast cancer treatment coverage before the treatment is finished, while the bureaucrats at Ramsey County and Keith Ellison, who supposedly is a fighter for, quality health care coverage, they want to take that money from these patients, and they want to redistribute that money to what they consider are more impoverished people or more worthy patients. So it's currently at the Minnesota Court of Appeals, but the issue of why they are not paying benefit payments on appeal so that this appeal can be brought without the period of brutal need where it's all cut off and you'd have to just fight to survive to pay for some medical care to give you the standard of care expected by the Medicaid Act. So that is very difficult to fight during that period of brutal need for justice. And so we hope that you will look at this and will help us and support us to help hundreds of women to get the breast cancer treatment they are promised under the law and Constitution. So this appeal currently at the Minnesota Court of Appeals, it's case number A18-1380, is proceeding without any MABC payments to the patient, Victoria, during her period of limitations, which means the time in which it's been determined by your doctor that she requires the promised and only partially provided medical care for the breast cancer. So the jurisdictional issue is the Court of Appeals has received all the briefs, and they are proceeding on that. However, this is a collateral order or judgment on which is before the U.S. Supreme Court. Now, on September 25th, 2018, petitioners filed a petition for mandamus in the Minnesota Court of Appeals to force the continuous coverage and payments pending the appeal of the denial of MABC medical assistance benefits to Victoria, which she is entitled to receive all the way to the Supreme Court pursuant to Minnesota law. The Minnesota Appellate Court issued its opinion, however, denying that continued payment pending appeal on October 16th, 2018 is when they issued that. And petitioners filed with the Minnesota Supreme Court a petition for review, and that petition was, however, denied December 18th, 2018. On March 18th, 2019, petitioners filed timely under Rule 13.1 a petition for a writ of certiorari to the Minnesota Supreme Court challenging the denial of continuing payments on appeal and seeking an order to the district court and the commissioner to order the agency to make medical assistance payments for medical care during Victoria's period of cancer treatment and pending appeal. The final decision of the Minnesota Appellate Court on the issue of barring continuing payments of the benefits is an appealable order or judgment under this court's precedent, the U.S. Supreme Court's precedent of Cohen versus Beneficial. That's from 1949. This court has jurisdiction to review on a writ of certiorari this final appealable order, where the Minnesota Supreme Court could have reviewed the Minnesota appellate decision A18-1578, but where the validity of the Minnesota statutes are drawn into question as applied and implemented as being repugnant to the Constitution's 14th Amendment substantive and procedural due process clause. And the corresponding federal statutes and regulations in the Medicaid Act are unduly burdened or violated by these violations of procedural and substantive due process under these statutes. Now, the court has jurisdiction to stay the execution and enforcement of the Minnesota Supreme Court and Minnesota Appeals Court judgment, barring continued benefits to Victoria's pending review on a writ of certiorari, see 28 U.S.C. 1257A and 2101F. Statement of the case, factual and statutory background. This application seeks a stay on the enforcement of the bar to continuing payment of Victoria's MABC, and a finding by the court allowing the continuing payment of those benefits during a reasonable period, that is to say, pending the filing and disposition of the pending writ or a petition for writ of certiorari, number 18.8511, and that is called Victoria Carlson et Veer. That husband is me, and that's versus Emily Johnson Piper, the former commissioner of the Minnesota Department of Human Services. And also the filing and disposition on the issue as part of the pending appeal 18-1380 at the Minnesota Appeals Court. And that appeal is based on repeated terminations of the breast cancer treatment coverage payments to providers since significantly before the patient attained age 65 in 2016. So that's years ago, as well as the larger question of the limitations period of eligible recipients in the MABC cancer program under the Federal Breast and Cervical Cancer Prevention and Treatment Act. Now, in addition to the factual and statutory background discussed supra, Victoria is an eligible recipient of the BCCPTA who has been treated for breast cancer and will be through November 2020 under coverage provided through the Medical Assistance Breast and Cervical Cancer Special Category Medical Assistance Program. Respondents say now, however, this is the commissioner in Ramsey County, that she's no longer eligible for the breast cancer treatment program and coverage to complete the treatment which was begun and prescribed in private consultation with her doctor. They say this is not a claim of right separable from those other rights which are before the state court, but the case, the issue of whether she's entitled to continuing payments pending appeal has been finally determined by Minnesota state courts, who found in the Court of Appeals, quote, appellant is not entitled to continue receiving MABC benefits during the appeal to this court, unquote. It is that determination sought to be reviewed by number 18.8511 or 18-8511, which you can find at the U.S. Supreme Court website through a docket search, and you can click on the cert petition and you can actually read the petition for a writ of certiorari. Now, in this application, petitioners asked the court through a single justice to stay the enforcement of that decision to bar payment for a reasonable time until the court has a chance to review by certiorari and to allow MABC payment pending appeal, because that is the law. We believe the standards set forth by this court for the stay are readily satisfied in this case, in that the federal and state law and requirements of the 14th Amendment are clear that she must be paid. That is to say, she must not be deprived of those payments without a 14th Amendment procedural due process requirements and substantive due process, which the record shows she has not had either of these. The one evidentiary hearing was on the wrongful conduct of the agency, and that was a favorable outcome to her and to petitioners, since it reversed that conduct, granted us due process rights, including payment pending appeal, which respondents refused. The Ramsey County and the commissioner now assert, and the Minnesota Appellate Court, sitting in original jurisdiction, erroneously found that the subject matter of the hearing resulting in the Commissioner's order to pay benefits to Victoria pending appeal was about whether when she turned 65, she would have lost her status as an eligible recipient of MABC and therefore should be treated as ineligible by the state. However, the action appealed from terminating Victoria occurred in July 2016, while her 65th birthday was November 11th, 2016. This obviously violates the 14th Amendment, as this court stated the requirements in Goldberg versus Kelly, that is, requiring a fair hearing prior to the termination. This is post-termination. The proposition that Victoria is, quote, no longer eligible, unquote, was not the subject matter of the evidentiary hearing and could not, for a number of reasons, have been. The constitutional and civil rights violations in the determination that Victoria could be deprived in this way were not, according to the Commissioner, even allowed by Minnesota law to be raised, presented, and determined in the administrative appeal process. And we ask that this law, excluding this, as applied, be void as violating due process, both substantive and procedural, under the 14th Amendment, and as unduly burdening the right to complete the cancer treatment, and as being vague and ambiguous, since there's no logical connection between when you begin your treatment and when you turn 65. As long as it's before 65, then if you can't complete your treatment, that is not in the statute at all. It's very vague and ambiguous. Now, since not all claims or defenses of petitioners arising under state or federal law were allowed to be heard, the proceeding cannot be used as a basis for res judicata or collateral estoppel on those excluded issues. That is to say, they can't say if you weren't allowed to raise it or the judge wasn't allowed to determine it, that it was in fact already determined and therefore is res judicata, something that's been adjudicated. And it actually could not be used to make any determination that she was no longer eligible when she was 65. The Commissioner, because that involves constitutional and civil rights issues. Now, the Commissioner reversed the agency's action because she found Victoria was eligible for MABC. The Commissioner ordered procedural due process going forward, including payments pending appeal. The agency was required to prepare adequate notice and present it to us, and an agency appeal summary was required by law, and they were required to allow further appeal on their contemplated transfer to the elderly program that paid no benefits. Now, the subject matter of her eligibility at 65 was also not within the scope of the Commissioner's order, which reversed an action taken in July 2016 terminating Victoria from MABC, and ordered corrective action for multiple deprivations of payments beginning in July 2016. The Commissioner found that MA with a spend-down was restored on November 1st, 2016, but that's with a spend-down. That's not MABC, which required no spend-down. Moreover, the core findings of the Commissioner and her order do not support the conclusion that Victoria is no longer eligible, only that this was the position the agency asserted, that Victoria is no longer eligible. This was in April of 2017, not that at any time relevant to the appeal she was no longer eligible. When they cut her off, she was eligible. And we assert she remains eligible. But that's in the merits case before the Court of Appeals. Now, the Commissioner implied that if the agency had terminated her MABC in December 2016 and transferred her to an elderly program with no benefits, the Commissioner would evidently have affirmed that action. But that had not happened. MABC had been terminated July 2016 and was not restored. Petitioners appealed the wrongful action of the agency, which is clearly spelled out in the Commissioner's order. After this illegal conduct, and in response to the order of the Commissioner's reversal and for corrective action, including continuing payments on appeal, which the agency refused, the notice provided by the agency literally criminalizes attempts to use Victoria's MABC benefits. Quote, do not use your Minnesota Healthcare Program's ID card after your coverage ends, which they said would be July 1st, 2017. If you use these cards after your coverage ends, you may be guilty of a crime, unquote. This is to a cancer patient in a special categorical treatment program. Now, some procedural history. After the Commissioner overturned the action of the county with HSJ Longfellow, who considered all the evidence and told the agency to give petitioner their legal grounds for the action, which they called a program change to the elderly program with no benefits, and a meaningful chance to oppose it, the agency sent out the notice just above that she may be guilty of a crime if she uses anything past July 1st. Petitioners filed their appeal with the agency as the law provides on June 23rd and asked for the benefits to be kept in place on appeal. Well, they said that all appeals were exhausted and there could not ever be any more benefits at all from MABC, let alone on appeal. They never intended to comply. The Commissioner purports to have somehow altered her decision of June 8th to pay benefits on appeal, which triggered this subdivision 10, which in pertinent part reads, quote, if the Commissioner of Human Services orders services paid or provided in any proceeding under this section, it shall be paid or provided pending appeal to the Commissioner of Human Services, District Court, Court of Appeals, or Supreme Court, unquote. The Commissioner did order medical care under MABC to be paid pending appeal under Subdivision 5 and Subdivision 3 of that section, 256.045, based on the fair hearing and the findings issued based on that fair hearing. And the Minnesota Court of Appeal actually cites the Commissioner's order, quote, petitioners rely on the Commissioner's statement in the June 8, 2018 order that the MAB benefits should be extended, quote, while the appeal, that's put in italics, appeal is pending, and until the agency can provide adequate notice of the program change to petitioners, unquote. Well, they go on to say that that was only done because it's done for all people in all appeals. Well, that is not true. But in fact, it was the state statute, Subdivision 3 of Minnesota Statutes 256.045 about fair hearings, and not the administrative procedures that required a fair hearing, and also that there's a corresponding federal statute, 42-1396A3, and these benefits, these include benefits pending appeal, and we requested them as demanded by the notice of appeal we received October 5th of 2016. As such, Subdivision 10 was in fact triggered by the Commissioner's order because Subdivision 3 is one of, quote, any proceeding under this section, 256.045, unquote. And it was in this proceeding that the Commissioner ordered the payments. The fact that there exist administrative procedures for the proceeding of the fair hearing, which were not followed by the agency, does not mean the Subdivision 3 fair hearing was not one of the covered proceedings. Moreover, the Minnesota Appellate Court suggesting the language of the appeal, unquote, being pending concerned only the initial administrative appeal to the Commissioner of Human Services is without authority and erroneous based on the plain language of Subdivision 10 itself, since the very statute classifies as appeal appeal to the Commissioner of Human Services, District Court, Court of Appeals, or Supreme Court, unquote. All of these are appeal. So the force of the Commissioner's order did not end when administrative appeals were ended, and that was not until August 30th, 2017, yet the benefits were finally terminated before that, July 1st, 2017. Finally, the court should note that the statute subdivision 10 provides only one method for the commissioner to have changed her mind and reduced or terminated the benefits pending appeal that she ordered. It had to have been before a final order was issued, that is June 8th, 2017, and Longfellow would have had to determine at the hearing, April 13th, 2017, that, quote, the sole issue on appeal is one of change in state or federal law, unquote, end of quote, and this simply did not happen. So the force of the Commissioner's order, which was based on a favorable outcome for petitioners, should remain in force until the Supreme Court, whether or not the Minnesota or U.S. court is not relevant at this point, since the Court of Appeals is clearly within the scope of the order to pay, and that's where the appeal is now. Petitioners contend here that Minnesota's hearing procedures must conform with Goldberg's requirements for adequate notice and opportunity to be heard, which in this case is the fair hearing, in order to meet constitutional muster under the 14th Amendment procedural due process requirements. So if rules and statutes did apply, as Minnesota Court of Appeals say they do, which would cut off the continued payments pending appeal, that is to say, to create a deprivation and create the potential for treating an eligible recipient as ineligible erroneously, it would be void and invalid as constitutionally flawed under the 14th Amendment. For these payment procedures are intended to conform with Goldberg if there is the possibility that depriving all women in MABC of their treatment coverage automatically at 65, or if they fail to request benefits in place on appeal within 10 days, if these practices do violate the Constitution or civil rights, and if these laws are not even allowed to be discussed as a final decision is reached, as they are not allowed in Minnesota, then those laws and regulations are unconstitutional. On the other hand, petitioners believe they could be interpreted in a way that does conform with Goldberg. Because although we disagree with Longfellow's dicta about Victoria being no longer eligible for MABC, but may be transferred to the elderly program with a punitive spend down, requiring us to spend ourselves down to 20% below poverty every month she gets a penny for medical assistance, that idea could be tested if adequate notice of that intended program change were to be provided to us, and if we had an opportunity to raise the constitutional and civil rights issues with an HSJ. In such a scenario, those practices would be constitutionally valid. But for now, pending a petition for certiorari on the whole case, we are simply asking the U.S. Supreme Court to constitutionally interpret Subdivision 10 and, of course, some of the other provisions that have not been discussed in this short reading. Essentially, what the Minnesota courts are doing at the bidding of the agency, that is the Ramsey County, and also the Keith Ellison and the Minnesota Department of Human Services, is to place the entire case into post-termination review, and that violates petitioners' rights, especially Victoria's. This is the only case in Minnesota which challenges the practice of arbitrary termination without notice or due process, and crippling the due process protections intended to help cancer patients finish their treatment. In these circumstances, and based on the findings of the Minnesota Court of Appeals, the payment is constitutionally required because Victoria could still be an eligible recipient. We believe she is, but we have not had the chance to meet the arguments of the commissioner, and she has been treated as ineligible for literally years and is so treated now. And that, we submit, is constitutionally unacceptable. Thank you for listening, And we hope that you will join with us to protect these hundreds of women against being deprived in this very hideous way as their money is seized and redistributed as welfare payments and endangering this very important program.